I'm Freddie Gathorne-Hardy. I'm the Managing Director of Christies Care.
Hello, I'm Emma Farrar. I'm a solicitor, consultant solicitor at Fairweather Law.
And I'm Jack Fairweather. I run Fairweather Law with offices throughout Suffolk, and I'm head of our private client department, which includes lasting power of attorneys.
So first question, what is a power of attorney?
So a lasting power of attorney is a legal document that allows people to appoint people to look after them in the event that they can no longer do so themselves.
And why should anyone actually have a power of attorney?
Generally, I try and explain it a bit like an insurance policy. So you hope that you never need the document, but if you do, you're really glad that you organised it in advance. It enables you to choose who you want to make decisions for you if and when you are not able to. So it's your choice of who you trust to make those decisions for you, either about your finances or about your health or your welfare, where you live and what care and support you need.
It's a common misconception that only people who are in their 60s, 70s and 80s should be thinking about lasting power of attorneys. Everyone should be thinking about it.
So if you lose mental capacity to make your own decisions and you have no lasting power of attorney, then the only way a person can make decisions for you is to be appointed by the Court of Protection. A, it takes a lot longer to go through the Court of Protection, and B, it's a lot more expensive. The process with legal fees and with court application fees is a lot more expensive.
And I think the key point is that if you don't have capacity, you do not get the say in who looks after you. Whereas if you make a lasting power of attorney whilst you still have capacity, you are deciding, when you have the ability to make that decision, who looks after you in the future. So you can make a reasoned decision about the type of person you want looking after you. Someone reliable, someone you trust, someone who has your best interests at heart. If you leave it too late and you lose capacity, that decision gets taken away from you, and you might end up with someone that you might not necessarily want, or someone you might know doesn't have your best interests at heart, making important life-changing decisions for you.
Can your attorney then straight away get into your bank account and steal all your money?
Power of attorney has certain duties and obligations called fiduciary duties, which they have to comply with. So an attorney should always act in your best interest. They should always consider your position above any interests of themselves, and they should always use your money for you. They should never take your money for their purposes. And the whole point of making a power of attorney is that you appoint the people you trust. So if there is somebody that you're not sure about or you don't trust them, quite simply, you shouldn't be appointing them. If you put a restriction in saying it's only when you lose mental capacity, it might not be as effective as you would want it to be. So no, your children shouldn't steal your money, but potentially, depending on how the power of attorney is drafted, yes, they could access your bank account as soon as the power of attorney is registered. So you do need to think about who you appoint.
Your attorneys must act in your best interests. So the key question is, how do you determine what is in anyone's best interests? And the question that the attorneys must ask themselves whenever they are faced with a decision is, what would the person you are making a decision for have done if they had been able to make that decision? So the attorneys put themselves in the shoes of the donor, who is the person who is making them, and they consider any guidance they've been given, any written instructions, any conversations they had with the donor before they lost capacity, and then make a decision on that basis. So if they go into the bank accounts, steal all the money, that is clearly not in that person's best interest. That is not something they would have done if they had capacity. So that would be, to my mind, a clear breach of the attorney's fiduciary duties to the donor.
There are processes to raise a safeguarding concern about an attorney's action. So if an attorney does start misusing the donor's funds, quite often banks will flag it, they will raise it with the Office of the Public Guardian, and then the Public Guardian will investigate. The investigations are quite lengthy and are quite detailed, and the success rate of them varies depending on the person's capacity, but there is a system in place to check that, and quite often it is banks that do flag things like that. So there is some reassurance in that the banks are aware that if an attorney is acting and large sums of money are being transferred to the attorney's account, then banks will flag it.
And there are serious repercussions for attorney that is found to be abusing their position. Essentially, that's a criminal act and they could be prosecuted for that. But you do often get situations where an attorney, through no fault of their own, is in a difficult position, or there is a possible position of conflict on the horizon, and we have to navigate that for the attorney. So what are the best things they can be doing to protect their position, to make sure a judge cannot accuse them of acting in a way that would be in breach of their fiduciary duties? So that, again, is another important aspect of our job in advising in this area.
And those can be conflicts of interest between the donor and attorney that were never anticipated. So husband and wife, for example, one of the spouses lacks capacity and has gone into care, and the other wants to move and use the proceeds from their joint property for another property for themselves. Or if you've appointed children and the children want to move, say, mum with dementia into their home and build a granny annex on for mum and use some of mum's money, there's a clear conflict of interest in doing situations like that, because you're adding value to the attorney's property whilst also trying to care for mum at home and continue to be able to provide and support for her. But as an attorney, you are in a conflict of interest situation. So those situations need some thought as and when they arise if you're acting as an attorney.
And how should I get a power of attorney?
It's possible for lay donors to make their own powers of attorney or to ask people to do it for them. You would have to visit the website of the Office of the Public Guardian, download the necessary forms, complete them, send them back, so on and so forth. Most people would prefer to engage with a professional service provider. If you have them made professionally, you will go through a questionnaire with your solicitor, and the solicitor will draft the document in a bespoke manner and include provisions that might otherwise be overlooked if you try to do them yourself. So our advice would be, by all means, have a go at doing them yourselves, but it might be worth at least having a professional look over it, or if not, do it for you, because they can be difficult forms, they are long, and mistakes can be made.
There's some very simple mistakes that if you tick the wrong box on how you want your attorneys can act, that can cause all sorts of banking complications. It's wise to get a solicitor or a capacity assessor to confirm that the person does understand what they're signing. There are some easy read guides. The MenCap website is very good and has got some easy read picture and simple language explanations, and sometimes I've used those with clients, not just clients with a learning disability, but clients of an older generation who have never dealt with legal forms and paperwork before. It's quite helpful to sit and go through those in quite an easy format to explain what a power of attorney is. So you can do it yourself, but there are advantages to getting a professional to get it right for you.
Can you please give me an example of how not having a power of attorney has had a bad impact on, for example, one of your clients or someone you know?
Clients who there is significant family dispute around what is in mum's best interest. Should they be cared for at home? Should they be cared for in a residential care home? Should they live with child A, child B, child C? If that person had made a lasting power of attorney around health and welfare, then there would be a clear person appointed to make that decision, rather than all three children arguing about where mum lives or who mum lives with. They're probably the ones that come up the most, about where is a person going to live and what care and support do they need. And I think things like dementia and cognitive issues are very difficult. Some people deal with the changes in the person's personality and their capabilities much better than others. And I think for other people, it's very hard and very traumatic to see their parent really changing over sometimes a very short period of time. And to be able to deal with and accept that actually life is very different now and we have to deal with it in a different way. So I think choosing who you want to make those decisions for you, if the worst happens, whether it's suddenly or a gradual decline, is really important. But also having conversations with your family about what you would want. You've chosen your attorney that you think is best, that would make the decision you would want to?
Emma and I were advising a client probably about 18 months ago, 2 years ago now, and the client had a couple of children, and we identified it quite early, but she was clearly struggling mentally, and she was going through a phase of her life where she didn't know who to trust. She was paranoid and suspicious of all of her loved ones, her children, siblings, and then in the end the family unit completely disintegrated, and the mother, our client, ended up meeting a new partner who clearly saw an opportunity there and took advantage of someone who was vulnerable because she'd been effectively abandoned by her loved ones, and we never saw her again. She appointed new solicitors, and that's not anything to do with us anymore. But the point is that if she had had a lasting power of attorney made when she was able to make it, appointing her loved ones who we considered had her best interests at heart, then the whole problem wouldn't have happened, because you would have had someone there who could easily have identified her fall into paranoia and probably dementia, identified it early, and started making decisions with us involved as well to make sure that our client was getting the right advice from the right people.
It is very difficult. We currently have some clients that we act for as an attorney, and the Mental Capacity Act says that there is a presumption of capacity, and you have to allow a client to make as many of their own decisions as you can do. We currently have some clients who are bordering on lacking capacity. My role at the moment, because they have a degree of capacity to make their own decisions, albeit decisions that I might not agree with or that I might not think are financially sensible, but I have to let them make their own decisions for as long as they are able to, but then step in when we get to a point of no return, or a point that can't let it go on any longer. And for family members, when there's that emotional link between the donor and the attorney, sometimes that's very difficult. My experience is that families fall out less about money than they do about where a person lives and what care and support they need.
So there are two types of lasting power of attorney, one for your property and financial affairs and another one for your health and welfare. The lasting power of attorney for property and financial affairs relates to running your bank account, paying your bills, selling property, managing investment portfolio, all of those types of decisions. The lasting power of attorney for health and welfare relates to decisions like your diet, your medication, the level of care you need, whether you should have carers visiting you at home, whether you should be in a care home, and right up to potentially making a decision about life-sustaining treatment. So if you are being kept alive artificially by a life support machine and the doctors assess that you have little prospect of good quality of life, then provided you've given your consent to this decision, then your attorneys can say, please turn the life support machine off. I know mother wouldn't want to be kept alive in these circumstances. The power of attorney for health and welfare is only usable when the donor has lost capacity, and it's always decision specific. So the donor might have capacity to decide what they'll have for lunch that day, but they might not have capacity to decide that they want to continue living at home where it's clearly inappropriate. So whenever there's a decision to be made, the attorneys must ask themselves how far the donor should be involved in that decision-making process and work backwards from there. The lasting power of attorney for property and financial affairs is clearly usable when the donor has lost capacity, but it's also usable when the donor still has capacity, provided they give their consent. They can still think for themselves and make decisions for themselves, but can't walk to the bank to pay a check-in, but they can give their consent for their attorney to do that on their behalf.
For financial affairs, if you simply don't want to deal with your finances anymore, I remember my grandmother was in her late 90s. She was still very switched on and very able to deal with her finances, but was just too tired with life and trying to deal with internet banking or to sort out her shares and investments. She just didn't want the hassle of that anymore. So my parents acted as her power of attorney while she had capacity, while she was still able to make her own decisions, but they just dealt with the paperwork for her. For health, as a doctor looking at a person in a bed who's quite poorly and who's come in for a fall or a UTI or something like that, they have to make decisions quite quickly. And I think if you're going to give your attorneys permission to make life-sustaining decisions, that's really important to think about. Who would you want to make the decision? Would you want a doctor to make a decision based on a discussion with your family, but the doctor will be making the decision on what medically they see on paper? Or would you rather your donors, your attorneys, your family perhaps, making the decision based on what they know about your quality of life? Again, with guidance from the doctors about medically how well you are, but probably your family or your attorneys are generally the people that know you best.
And if you haven't got a family, who else can be your attorney?
We can act as attorneys. Jack and I have a number of clients where we're actively acting for them, either in terms of finances or, as I said earlier, in terms of welfare. Other professionals will do it as well. I would say that if you're appointing a professional to make health and welfare decisions for you, they need to be a professional that knows you well. So you need to have an ongoing relationship. So for all of our clients, either Jack or I keep in touch with them. Mostly we go and see our clients at least once a year, even if we're not actively involved with them, to see how things are, whether their views have changed on particular things, so that if they were suddenly taken into hospital, we would know what they would want, and that we would know where their assets are, so we can manage a client's assets, or we can be in the background. We can act as replacement. So we have some clients that appoint a family member or a friend to act as their attorney, but if that person, so they might appoint a husband or wife, but if that person lost capacity or couldn't act for them for some reason, then we would step up and be the backup.
Can you explain the terms surrounding power of attorney?
Power of attorney, or lasting power of attorney, sometimes people often call it LPA for short. So there's lasting power of attorney. The person that makes the power of attorney is donating it to somebody else. So the person that makes the power of attorney, that's choosing who they want to make decisions for them, is called the donor. And the person they are giving power of attorney to is the attorney. You can have one or more than attorneys. You can have 4 attorneys. They can be appointed to act jointly, which means that everybody has to act together, or jointly and severally, which means any one of them can act. And you can have replacement attorneys. So quite often clients will come in and see us and say, husband and wife, we want to appoint each other, and then as a replacement we want to appoint our children. When you make a power of attorney, you need somebody to act as a certificate provider to say that you understand the document you're signing. That can be the professional that you come in to see to get the power of attorney drafted, or it can be a doctor or a mental capacity assessor, or it can be somebody that's known you for a long time, but it needs to be somebody that is prepared to sit down with you and go through, do you know what you're signing? Can you tell me independently what this document does, who you are choosing to make decisions for you? Because the cases that I've seen where things go wrong is generally because the certificate provider has been the next door neighbour, and that actually the person really didn't understand what they were signing. Something was just put in front of them and signed. So the certificate provider is quite a responsibility for somebody to take on as well. We had a client, sadly passed away now. She was a real character, and somebody who has quite a special place in my heart now. I acted for her for quite a long period of time. I think it was nearly 10 years in the end. Asked to go and see her by a social worker, went and saw her, and she made a lasting power of attorney to appoint me to make finance and health decisions for her. She was a colourful character. She lived a life to the full. She met Colonel Gaddafi. The stories that this lady had were fantastic. But she also was very clear about how she wanted to live her life. She liked to smoke and she liked to drink, and she drank heavily, and she was absolutely adamant she wanted to remain at home. We kept her at home until almost the very, very end. Throughout that, there were some tricky times. She fell down the stairs and broke her neck. At the time, I think think 2 or 3 weeks before I'd had a baby, and I got a phone call from the hospital saying, your client's fallen down the stairs and broken her neck, we want to know what to do. So with the baby, I went off to the hospital to have a conversation, and the hospital were very adamant she wouldn't walk again and she wouldn't do this and she wouldn't do that. But knowing my client, I was pretty sure that if there was a glass of wine at the end of the corridor, she would be getting up and walking. And sure enough, she did get up and walk. Lived independently, well, with support at home, but as independent as was possible in her own home in Suffolk for probably another 5 years after she broke her neck. And we were able to keep her at home. It was incredibly hard work and she was a real challenge at times, but we did what she asked us to do. And the point that we couldn't keep her at home any longer, she didn't really recognise her surroundings. So although I did have to make a decision that ultimately I knew she didn't want, I also knew that she didn't know where she was anymore. Her home wasn't her home anymore. And actually, we got her settled into a care home, but we made her room just like it was at home. So she didn't really know that she wasn't at home. She was very happy until the end. I felt quite honoured to have been part of that lady's life for a long time and to have been entrusted by her to support her both with her finances, which were quite significant assets at the beginning, and in terms of those decisions for a long period of time. So although it is a professional appointment, it is one that both Jack and I take quite seriously.
Thank you both very, very much for coming today and teaching us about powers of attorney. They're really vital for our clients and for actually, as you've told me, everyone. So thanks very much for your insight.